Thank you very much. I had to mention that I am not professor. I hope that not yet. So, first of all, please, professors and members of audience, please excuse me for my poor pronunciation in English, because I use French language in most of the time. So I'm assistant professor at the Károli Gáspár University, and frequently I do research with the Central European Academy. I decide to give a speech to you instead of presentation, because I don't want to divide your attention between regarding and hearing my long and complicated sentence about EU law. It's not a normal term, so I think that it's better like this. So probably you might find the title of this presentation astonishing, arguing that this field falls within the competence of the member states, while the European Commission generally formulate a recommendation in this field, which usually lack binding force for the member state. Obviously, I have to agree with this statement. None other less by applying an extensive interpretation of the existing EU directive, the Court of Justice of the European Union developed a case law that can have a severe effect on the family allowance introduced by the member states in order to stimulate positive demographic changes. In the following, I shall examine this case law and the challenge posted by it, followed by the formulation of proposal for a solution. First, I shall examine a question for written answer submitted by the members of the European Parliament, with particular regard to the fact that the said case law of the court, which I will present later, was not specifically mentioned in an answer given by the European Commission, even though it can exert a considerable influence and present a significant constraint in this field for the member states. So this question for written answer concerned policy aimed at supporting families. The members of the European Parliament sought to know whether the European Commission considered that supporting Europeans in having more children might also alleviate labor force issues. The second part of questions asked by the Commission with basically identical content, whether its plans to promote the idea of having more children in the light of demographic crisis, or if or not, why not? The question for written answer also asks whether the Commission considered promoting and facilitating motherhood and proposing policies that support and encourage larger traditional families, as according to the member of the European Parliament who submitted this question, this also should form a part of the European way of life. In its answer, the Commission essentially stressed that it supports the member state in creating favorable conditions enabling EU citizens to plan their family life. Apart from its supportive measures, such as the support for investments in childcare facilities or the directive or work-life balance, the Commission considers this area to be field that basically falls within the scope of member state competence and the member state responsibilities. Despite the answer given by the Commission, in what way do EU requirements appear in the court case law? Two layers can be distinguished. Layer 1, EU control of the subsidies aimed at demographic incentive, which appear through the court's extensive interpretation of the measure concerning the discrimination on ground of age or sex. The first judgment is Gáspár case. According to the Court of Justice, French law providing service credit for women in respect to bringing up their children constitute a breach of EU law. The court decision was based on the primary EU legislation prohibiting discrimination on ground of sex and the Directive 75. Judgment in the Leone case. The French legislator extended the service credit and issued to men, thus, after such amendment, the national law providing a service credit in respect of the bringing up of children become neutral in terms of sex. None otherwise, according to the interpretation of the Court of Justice, the national law and issue still failed to meet the criteria of the EU law, and the court ruled that the regulation and issue resulted in indirect discrimination, as many more women than men received the benefit concerned. And the judgment of the Instituto Nacional de la Seguridad Social case. So the Spanish law intended inter alia to grant a pension supplement to women who have children as an acknowledgement of their demographic contribution. The Spanish government relied also on social objectives. It presented statistical evidence showing that the pension payment to women are mother of two or more children is considerably lower than that of childless women or women who have had one child. These facts were not taken into account by the court. Finally, the court ruled that the national measure at issue did not meet the criteria of EU law. Layer 2, the extension of certain member state subsidies to same-sex couples or persons who live in an extramarital relationship, and further development of this case law by the Court of Justice. Judgment of the Tadao Markuru case. In this judgment, the court ruled on a benefit related to the support of families, which was provided by the given member state to married couples only. Pursuant the directive, the directive is exclude the case of the national law on marital status and the benefits dependent thereupon, notwithstanding the fact with the extensive interpretation of the regulation prohibiting the discrimination on ground of sex, the court ruled that, contrary to the provision set forth by the relevant German law and the constitutional fundamental law, the benefit at issue was to be provided also for the same-sex life partners. And the judgment to the MB Secretary of State case. According to the court judgment, EU law precludes a national legislation that requires inter alia a married person who has changed gender to annul his or her marriage in order to hold a full certificate of recognition of the change of gender, that is, to satisfy the condition of not being married to a person of the gender that he or she has acquired as a result of the change in order to be able to claim a certain type of retirement pension. The structure of the case law examined in the above two groups and their effects on member states' policies aimed at demographic incentives. I shall begin my examination with the judgment of the second groups. Based on the case law examined in the second group, certain member states' allowance or credit are to be provided also to the person who were not eligible to those allowances or credits according to the intent of member state legislation. For example, under certain circumstances, the provision of one allowance reserved for married couples cannot be refused in the case of life partners. We believe that this case law definitely requires attention. It is clear even from this brief summary that the court developed a rather extensive interpretation in this field, thus, notwithstanding the fact that family status and the related subsidies fall with the national competence, the member states must take EU law into account also in this field. In my opinion, however, this case law does not prevent the development of family policy aimed at the stimulation of positive demographic changes. The dogmatic behind the judgment examined in the first group is the following. In the main proceeding of the two judgments, the concerned member states, in order to address social realities, intended to compensate the disadvantage incurred by women who raise several children and they spend less time on their career due to the time spent on bringing up their children, which result in paying less pension contribution and thus receiving less pension payment. The directive prohibiting discrimination on ground of sex allow member states to introduce measures that provide compensation to a disadvantaged sex, and the directive recognizes the legitimacy of protecting a woman's biological condition during and after pregnancy, and well as that of protecting the special relationship between a woman and a child. However, according to the interpretation of the court, the provisions of compensation for the career disadvantaged incurred due to the bringing up of children is not justified in that regard, as compensation for career disadvantage can only be provided to women during their pregnancy and the weeks that follow childbirth. Neither did the court take the statistical evidence into account, which show that women who have more than 2 children receive significantly less pension payment. The court exercises rather strict control in this field, where the demographic objective does not appear as a public interest objective. EU law prohibiting discrimination on ground of sex preclude the provision of compensation to women who bring up children. Moreover, as we have seen, even if the national legislature extend the benefit and issue to men, the member state regulation concerned can still constitute indirect discrimination according to the court, as it may lead to a situation where many more women and men receive the benefit in the regard to the bringing up of children. In the light of the current existing case law concerning demography, it does not seem possible to further the demographic objective through the pension scheme. Moreover, it's reasonable to say that not only the pension-related demographic measures are precluded by the case law. Taking only EU law into account, not only regulations similar to the national measures examined in the judgment of the court may be hindered by the existing case law. Any member state legislation that intends to further the demographic objective by providing benefits to couples who have had or intend to have children, such as interest subsidized loans, facilities to buying real estate, typically include criteria related to sex or age or family status. And allow me to recall that even if a national law does not include criteria related to sex, it can still constitute indirect discrimination and ruled by the court in a Leone case if the benefit at issue is received by more women than men who bringing up children. Thus, such member state legislation can still be precluded by EU law. Perhaps the court case law related to the discrimination of ground of age does not appear to be so strict, but many examples show that the judgment rendered in that field due to their almost bureaucratic nature may also lead to uncertainties for member states in practice. A judgment of the court related to Germany mentioned in my study, which became the source of decade of legal uncertainty. And I have yet not knowledge of any judgment of courts related to the demography and discrimination on ground of age. Obviously, an objective such a demographic can only be furthered by long-term measures where families can trust that they will receive subsidies on the long run. The fact that the court judgment has yet been rendered in relation to the national regulation in force in Central Europe prove nothing but that the European Commission has not yet intended infringement proceeding and that no similar individual case has yet been tried by the Court of Justice. However, as we can see in other fields in relation to Hungary, such cases will eventually be tried by the Court of Justice. So, suggestion or solutions. Proposal A, amendment of the relevant act of the primary of the secondary EU legislation. The examined directive should include that member state subsidies aimed at demographic incentive as justified objectives. Proposal B, the development of scientifically high standard proposal to harmonize the objectives of examined case law of the court and the demographic objectives. This would require a cooperation between the researcher of as many member states as possible, as a result of which the developed proposal might permit into the Court of Justice case law through the opinion of the Advocate General. Distinguished professors, colleagues, I sincerely hope that my articulation of this issue deserves your attention, and I will have the opportunity to cooperate in this field with many of those present. Thank you for your attention.